Hello, everyone. Welcome to today's program, California Privacy Law on End-to-End Encryption of Direct Messages. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I am delighted to introduce our speaker, Don Dennis. Don is the founder of the law offices of Don R. Dennis Jr., where his practice focuses on copyright and trademark infringement, internet law, defamation, trade secret misappropriation, data security breach, and privacy law. Don is a certified information privacy professional with the International Association of Privacy Professionals. In addition to his legal practice, Don serves as an adjunct professor of law in the Los Angeles Community College District and is a frequent industry speaker and author on issues related to intellectual property and privacy law. Don is very enthusiastic to answer any questions you might have, so feel free to drop them into the Q&A and he will answer them at the end of the program. And now I'm going to turn it over to Don.
Hello. I'm glad everyone is here. And as you can see, it says on your screen, does Meta have to keep my DMs, meaning direct messages, on the hush hush? California privacy law on end-to-end encryption of my direct messages. So today my plan is to give you the truth, the whole truth, and nothing but the truth. In our brief time, we don't have time for appetizers. We need to go straight to the main course. If you need any additional information, there's an article I wrote about this topic in the April 23rd, 2026 Daily Journal. And the article title was Meta Ends Encrypted IG DMs, and you'll find a lot of details there. So let's talk about communication real quick. When we're thinking about communication, we all are familiar with the idea of our inside voice, our outside voice, and then a whisper. And if you think about how we as a civilization here in the US have evolved with respect to communication, many years ago, everyone had to use phone booths. Now they're pretty much extinct. Or I'm sorry, use phones that were on like stands outside. And you would insert money in them, coins that are you don't really see too often anymore. And then from there, if you wanted to have a private conversation and you were outside somewhere, people would step into a phone booth because you could close the door and you'd be secure from other people listening to what your private conversation was. And then also you think about the idea of people would have an office phone. And if they wanted to talk about something private at their office in their business, they'd shut the door, and people still do that. And then also many years ago, people would have home phones through companies like AT&T that were wired and have a cord, and they would maybe have a home phone or a phone inside of your bedroom. And people would do that because they want to have a private conversation. And now people have cell phones, and they're having their cell phones. And you've seen many times people will be in a crowd and they'll walk away because they again want privacy. And the idea is people want to communicate important instant messages, talk to someone, communicate a thought, an idea, an urge they have within them. But now a significant amount of communication occurs via social media. So therefore, in the average user's mind, they have that same level of privacy that they would have in any other media. So on March the 9th, 2026, Meta posted that very few people were opting into end-to-end encrypted messaging in DMs. So we're removing this option from Instagram in the coming months. You can keep messaging with end-to-end encryption easily on WhatsApp. Now, Meta made this post. How many people do you think actually read this post? How many people actually read the post that are provided by social media companies, follow their news feeds, things of that nature? I don't know, but I don't know if the number is that high. If you could please advance the slide. Okay. So thank you, Ala. She went over my ingredients. And yes, I'm a professor of law, and I deal with a lot of cybersecurity issues, the key word being security, because people want certain things, certain communications to remain secure. And when they find out, or if someone learns that their private information has been exposed, such as in a data incident or a data security breach, people get upset, they start to panic, and everyone starts dusting for fingerprints to figure out who the culprits are or who the culprits were that exposed that information that they wanted to remain private. Please advance the slide. Okay. So, oh, I'm sorry. Could you please go back? Thank you. There we go. Thank you very much. So, when we're thinking about the significance of direct messages in society, again, we're focusing on the idea that people want to communicate a message. Now, as you know, and a lot of people understand, people do things sometimes for clicks. They do things to go viral, whether it's on TikTok, whether it's on Instagram or Facebook. People do challenges, things of that nature. And they want when they want everyone to know what they're doing, it's done in a post, it's done in a reel, it's done in a status update, or it's done on an Instagram live feed or a Facebook live feed or a YouTube live feed. Nevertheless, people still have certain information they do not want disclosed. Therefore, they will send it through a direct message. A direct message is an off screen private message that someone could send specifically to one other person, to a group of people, maybe their friends, maybe their colleagues, maybe their relatives, and it's not designed to be shared with everyone. The key idea in individuals' minds when they send this message is that they're going to have privacy. It's not going to be public information. So when we're talking about privacy and we're talking about privacy law, we're going to go a little bit into what exactly that means if you are a resident of California. If you could please go to the next slide. So in California, we have the California Consumer Privacy Act. As amended by the California Privacy Rights Act is our consumer privacy law. It details what and it defines what is personal information and what is sensitive personal information. In addition, it identifies examples of personal information under section 1798.140. So examples of personal information under California privacy law includes an individual's first name or first initial and last name in combination with their social security number or their driver's license number or medical information or their credit card or financial information such as your debit card and a way to log into that account. So these are just a few examples of personal information as defined by the California Consumer Privacy Act. And the bar has many great videos by other privacy practitioners that go into a lot of detail on the CCPA. There are some exceptions as to what is considered personal information, and that would include information that is publicly available, such as information that's lawfully made available by the federal, state, or local government records. That would not constitute personal information. In addition, there's other information that is not necessarily personal information, but I would suggest to you that individuals want to minimize accessibility to that information because it can communicate things such as things that they love, things that they like, or they dislike. Consider, for example, someone wants to send a message to someone announcing the birth of a child, announcing their plans to move, announcing their bar results, as we all are familiar with, and announcing or sharing with someone that, hey, I have to, with their friend or relative, there's someone I have a romantic interest in. Their fears, their discouragement, their setbacks, their business plans. The interesting part is individuals could be discussing matters that they feel are confidential through a direct message, and from a personal perspective mean a significant amount to them. However, the information that I just shared may in no way meet the definition of personal information. Therefore, it may not have any protection under the law being when it's disclosed via social media or any other online media method. And therefore, it's a little bit of a gray area because think about it. Do your friends and family and people that are not attorneys, people that you care about, that you're concerned about, do they understand this distinction? Do they understand that the normal conversations they might have on their telephone when they disclose that through social media doesn't have that same level of protection? Why is this important? This is important because a significant amount of communication that used to probably occur primarily when people were not in close relationship, close distance with each other, that would occur primarily over the phone, is now occurring through social media. The current generation typically communicates through social media. Many people do not answer their phone nowadays. Many people do not check voicemail. They are looking to receive communication via social media, and they are inevitably believing this information is not only confidential, not only private, but probably protected by the law. So when we're talking, let's get back to the CCPA, California Consumer Privacy Act. When we're talking about that, we talked about the definition as to what is personal information. But in addition to that, Californians have rights under the CCPA. And some of the rights that they have include the right to know what personal information has been collected about them, whether that personal information has been sold or disclosed, and to whom it was sold or disclosed, the right to say no to the sale of that personal information, to access that information, and other assorted rights. But these are some of the rights, and these are some of the definitions as to what's involved in the CCPA. If you could please advance the slide. End-to-end encryption. So this is the announcement as to what Meta said they were no longer going to provide because people were not opting into it. So what exactly is end-to-end encryption? Encryption is a means of concealing data, such as text messages, images, or video, from anyone who is not the intended recipient. So if I send a message to Allah, or if I send a message to someone else and our messages are encrypted, only I can access that message and only she can access that message. And so if we lock our phones and no one has the passcode to get in or our biometric information, those messages remain protected. And the way it works is it translates the data that constituted the message into a format that is unintelligible until it is retranslated back into its original form through the use of a decoding mechanism. Now, while forms of encryption have been used for many years, encrypted information can be impossible or nearly impossible to decode, even using sophisticated technology. So, as you see on the slide on the screen, the next bullet point says, is this really just because people weren't using the encryption function on Meta? Or is this about warrant-proof encryption? In 2025, I wrote an article for the Daily Journal talking about the concept of warrant-proof encryption. So what happens is, because of all the sophisticated encryption technologies, and I just spoke about how it's nearly impossible to decode the messages, the government enforcement agencies have said that it significantly impairs or entirely prevents many serious criminal and national security investigations because they can't get into the messaging. And if they don't have the cooperation from technology companies and to get to those messages, it thwarts things. And technology companies have said they cannot even get into those messages, which is what the article delved into. So while hence governmental agencies are calling this warrant-proof encryption, the FBI acknowledged this by saying that cell phone providers are often unable to deliver information to law enforcement about illegal and egregious harmful activity when they are compelled by court-authorized legal processes. The U.S. Department of Justice has referred to warrant-proof encryption as a lawless space that criminals, terrorists, and other bad actors can exploit for their nefarious ends. Thus, the government desires this cell phone providers to develop technology to circumvent it, but the cell phone providers had not done so. So the reason I raised this is because we were provided this idea from Meta that people weren't using it, therefore they were going to disable it. But I can't help but wonder if this had anything to do with pressure being placed upon them from governmental agencies to be able to crack these messages and get this information. But we don't know for certain. If you could please advance the slide. So now we're into the heart of the matter. Does the CCPA, California Consumer Privacy Act, require end-to-end encryption? Well, I hate to give the answer that we all heard many times in law school. It depends. But unfortunately, at this point, juncture, it's not necessarily definitive that it is required. In fact, I have on the screen where you're looking at a cybersecurity audit. So who has to complete a cybersecurity audit? What are we talking about? Well, if you meet the statutory definition of a business under the California Consumer Privacy Act, and you engage in the processing of personal information that I identified above, and that personal information also is deemed a significant risk under certain thresholds, you will have to perform your business a cybersecurity audit. So what constitutes a significant risk? Well, there are three factors. One, the nature of the processing of the business that's involved, the annual revenue, and the volume of personal and sensitive personal information that is processed. So if you derive 50% or more of annual revenue from selling or sharing personal information, then you have to perform a cybersecurity audit. If the annual gross revenue in the prior year is greater than 26.65 million and you've processed personal information of 250,000 or more consumers or households, or you process the sensitive personal information as defined by the CCPA of 50,000 people or more consumers, you're going to have to perform a cybersecurity audit. Now, we talked about personal information, and just to give additional context as to what sensitive personal information is, that would include social security numbers, someone's precise geolocation, someone's genetic data, also someone's biometric information. And when we say biometric, we're talking about retina, we're talking about iris scans, we're talking about fingerprints, we're talking about voice IDs. All of this information constitutes biometric information and therefore is sensitive personal information. Now, if a business meets the regulatory thresholds for cybersecurity audits, then they have to conduct the audit to evaluate the design and effectiveness of their cybersecurity program. Now, again, when we say a cybersecurity program, we're talking about things done online and how secure it is, how airtight it is, how safe it is. Is any system 100% perfect? No. The US Army has been hacked. The LAPD cybersecurity squad was hacked recently. Hospitals were hacked. Major, Canvas was hacked recently that major universities and colleges all over the country use. The White House, the Army, the military agencies. So hacks, breaches, data security incidents or breaches, however we're going to define it, have all been penetrated. Nevertheless, if you meet the thresholds that we've discussed above, you have to conduct a cybersecurity audit. Now, when they conduct this, we're looking to see what safeguards are in place to protect the personal information of users from unauthorized access, destruction, use, modifications, and other things that could result, that were unauthorized and can result in the loss of the personal information. But there's one key here, and the key is this. Although we're looking at safeguards you have in place, although we're looking at administrative procedures, technical procedures, and physical procedures that you have in place, the wording is always reasonable. What reasonable measures do you have in place? So when we talk about physical procedures, do you use lock cabinets? Do you have locked drawers, locked doors? Technological, do you have, everyone is required to input a passcode in the computer. You're required to have multi-factor authentication. You're required to update the passcode every 90 days. These are ideas. Administrative procedures. Are your employees trained? Are the businesses trained? Do they have to go through annual training? Do they have to go through lunch and learn updates, things of that nature on the latest malware, ransomware, and other attacks that are going on online? So these are a part of the types of things that are looked at. However, with respect to the cybersecurity audit, it mentions some of the things that they consider that show you are basically doing what you need to do include, for example, multi-factor authentication, that to resist phishing attacks for employees, independent contractors, and other personnel. So these are things that they would consider a good practice. Also, if the business uses passwords or passphrases, do the passwords or passphrases have to be strong or unique? And another thing that they list is encryption of personal information at rest and in transit. Now, again, these are measures that are considered, but not required. There, I believe, are a total of 18 different things that they will look at. However, you are not required to do all 18, and you're not required to do any one of the 18 in particular. So, is Meta actually required to say that to provide this end-to-end encryption? Not exactly. Do they process a large amount of personal information? It would appear they likely do, as would many other social media providers. If you could please advance to the next slide. So, why is there an issue with accepting Meta's position on confidential information? What is Meta's position on confidential information? Well, according to Meta's Privacy Center and Privacy Violations page, they tell users up front it's their stance on personal or confidential information. We do not allow people to post certain types of personal or confidential information about themselves or others. So they make it explicitly clear that you should not even be posting that type of information. They don't expect you to have it there. And by you doing it, and they've acknowledged this to you, you are basically violating their policy. So what do they say when they say personal identifiable information, you shouldn't post it? They list it specifically on their website. National identification numbers, social security numbers, passport numbers, government IDs, records, immigration information, personal contact information, residential information, information about your medical, information about your financial information. Again, this is posted in the Privacy Center. Does the average user, your friend, your relative, your neighbor that's not an attorney, read these updates? Know that the conversations that they're having may no longer have end-to-end encryption on Instagram. Are they familiar with this, or are they going about business as usual? In addition, what Meta says is we remove content that shares, offers, or solicits personally identifiable information or other private information that could lead to physical or financial harm, including financial, residential, and medical information, as well as private information obtained from illegal sources. So it begs the question again, why is there an issue with people accepting Meta's position on how confidential information should be disclosed using direct messages? And again, I would have to say, I don't really believe people are grasping this, the average Instagram user, whether it's a business or an individual, when they're sending out direct messages, because direct messages or the DMs are so popular and so many people use them. If you could please advance to the next slide. Now, one possible idea that I place for your consideration would be the idea of, could the FCC save the day? The FCC regulates, obviously, phone conversations. And they specifically make it a rule to protect private messages and communications data by regulating how telecommunications carriers use, disclose, and secure customer proprietary network information, such as call logs, text metadata. It enforces rules against unauthorized access to consumer information, illegal spoofing, and mandates that providers implement measures to block scam texts and calls. And in addition, every telecommunications carrier has a duty to protect the confidentiality of proprietary information of customers. But here's the thing: social media companies are not telecommunications carriers. I get that. I acknowledge it. It's very clear. But the idea is, if in the past century, most communication was done by the phone and people felt secure in their information being protected, and now a significant amount of communication is carried out being through direct messages, through social media, should the law change? Should the social media characters, I'm sorry, social media companies be made to conform to some of this same level of scrutiny and protection of confidential or private information that the FCC requires of telecommunication carriers? Is that what we should expect at this point in time? Because the bottom line is, we know that regardless of what Meta says, people are not going to stop sending and sharing confidential personal information through DMs, and things are going to continue. If you could please advance to the next slide. So if you have clients that are seeking advice and that are wondering how to navigate from their business standpoint with respect to this information, they want to make sure they're protected because they don't want their confidential information, even in the form of trade secrets or proprietary information that's very important to the business, to mistakenly get out or be exposed. You can feel free to call my office. My contact information is readily available. And without any further ado, I will take any questions that are available. And let me go here to the chat to see. I think we have something here. Question. Here we go. Do you have recommendations for consultants that perform cybersecurity audits? So we have a question, and the question is, do you have recommendations for consultants that perform cybersecurity audits? When we're talking about cybersecurity, first and foremost, what I would recommend is they obtain a clear understanding of how the business performs and also the types of data that are shared. So therefore, based on the type of data that's shared, that should dictate what type of reasonable security measures might need to be implemented. It's one thing if a consultant is evaluating Ralph's or Kroger or Vons in their corporate office to see the type of information that comes in there, as opposed to a consultant evaluating Kaiser, Cedars-Sinai, UCLA Health, or something like that, because there's different types of data. And then based on that, the consultant should recommend the necessary technology measures that should be implemented. Also, recommend the follow-up administrative policies, because it makes no sense to have these policies in place, to have these security measures in place, to put rules in place if they're not going to be enforced. Because if they're not enforced and they're not checked up upon and audits are not performed, they're just suggestions. Because the real work, the real issues come about when you see most data breaches, or when you see many data breaches in cybersecurity incidents. The problem becomes oftentimes there was a misstep or someone didn't follow through the process, even if they had been provided training and there had been no audit as to what should and shouldn't be done on a consistent basis. Were there any other questions? Okay. So I think that would constitute pretty much the end of this. But what I would encourage everyone to do is to make sure that you counsel and advise your clients as to the distinction between private information and between personal information that is protected by the law and puts requirements on companies as to how they must maintain, address, and protect your information, because there is a distinction, and everything that we feel is private and confidential is not necessarily deemed that same level of authority under the law.